Hi, everyone. Good afternoon. I'm Immigration Attorney Yael Brudner, coming to you live from Orange County, California, with some updates about immigration and a nice topic for today that I think would be really interesting for a lot of people. So the first thing I wanted to share with you guys, if you haven't heard about this, I talked about this shortly yesterday. Everyone was so excited about the news. Fees, the fee increase is frozen. So USCIS was planning to increase most of the filing fees for applications starting October 2nd. So we've been working really hard, not just us, firms across the US have been working really, really hard to get applications sent out before immigration increases the filing fees. Now, during this time, for several weeks now, there's been litigation in court filed by several nonprofit organizations asking the court to stop this fee increase. Okay, basically, the nonprofit organization sued the government, saying that it's not justified to increase the fees to this extent. There's no reasoning behind it, or the reason, when you balance the reasons, the harm is larger than the benefit. Okay, so the litigation has been going on for a long time. And last minute, the judge ordered an injunction, which means basically that immigration has to stop. They cannot go forward with implementing their new fee increase rule, until there is an outcome of this litigation. Okay, so this is a temporary freeze of the increase. So this is great. It's great news, but it's only temporary. Okay, first of all, the government can appeal, and there can be an outcome of the case where the court decides in favor of the government. Okay, just in general, the government can't just decide, make decisions to increase fees that will affect a lot of people with no really good reasoning behind it. So that's the basis of it. My advice to you stays the same. I think that if you are thinking about starting an immigration case, if you want to file for a family member, if you are thinking to file for citizenship, if you've been a lawful permanent resident for a long time, do it. Don't wait. This gives us a little bit of air, gives us a little bit more time. So we don't have the increase starting, Friday. Gives us a little bit more time, but still, I wouldn't wait, because, like I said, the increase, the freezing of this fee increase is only temporary, and we don't know when it will be lifted. It could be lifted any moment. We've seen similar things going on with DACA, with the public charge rule. For those of you who have been following me or following immigration news, every day there's something new. Every day there's another court case or decision that comes out, or a policy that comes out from USCIS that changes everything. So I would not wait. I would file right now if you are thinking of doing it. Okay, so I have a comment. Someone, Bolster, you're a lawful immigrant for 40 years. If you have a question, go ahead and ask it, and if I can answer, I'll try to do that. So in terms of the filing fees, we're good to go with the regular fees. No increase, everything is usual. Another thing that they wanted to change was a lot of the forms on the USCIS website were planned to change to accommodate the filing increase. So that's not happening as well. So right now, we're good to go with everything like it was before they announced this increase. Okay, if you have any questions, feel free to write them in the comments, and I'll try to answer them as we go. So I wanted to talk about a subject that we get a lot a lot of questions about, and I think would be very interesting for you guys. I want to talk about adjustment of status, what it is and how you can apply to adjust your status in the US. Okay, this is a subject that we get asked about a lot in our office, and that's what we do a lot. Most of our job, most of the work that we get here in the office is helping people apply for their green cards when they're here in the US. Okay, we also help people from abroad come, or people here bring family members, but from abroad. But we help a lot of people here in the US. So you might have heard adjustment of status, and that's just the technical term for applying for a green card in the US. That's what it is. And you have to meet specific requirements in order to qualify to adjust your status. Okay, and the first one that you need to meet is you need to be eligible for a green card. Okay, someone has to petition you, and this could be a family member or an employer. Okay, so you have to get someone that can petition you, and you need to get that petition in. And you need to have a visa available for you. Okay, so some categories, there's a wait. So for example, if you are a family member of what's called a preference category, let's say you are a brother or a sister of a US citizen. So that category is backlogged, and there's a lot of weight in that category. So you can't file for adjustment of status even if you have someone to petition you. Okay, so for adjustment of status, you have to both have someone that's going to petition you, and you have to have a visa available for you right now in order to apply to adjust your status. Okay, you need to have been maintaining status in the US. So that means that you have to be legally in the US with status to apply to adjust your status. Now, this is the general rule. Okay, for the general rule, you have to have a petition, someone petitioning you, you have to have a visa available for you, and you have to be maintaining status in the US, meaning you have to be legally here with status, and not breaking your status. Okay, maintaining it. By maintaining, I mean, if you're here as a visitor, you can't be working, okay, because that's not maintaining your status. So that's the general rule. However, there's the big exception of immediate relatives, and you might have heard about this. If you're married to a US citizen, you can apply to adjust your status even if you did not maintain your status. So even if you overstayed your visa or you work without authorization, you can still file for adjustment of status in the US without leaving. Okay, so if let's say you're married to a US citizen, or you're a US citizen petitioning your parents, for example, that's another immediate relative category. You can, and you have all of those things. You have the petition, you have the visa available for you, and you came in with a visa, then you can adjust status in the US. In that case, what we do is we file what's called a one-step application. We file your petition, we file your adjustment of status application. We also file for a work permit, work authorization for you, a travel document, and that's basically what's called the adjustment of status one-step application. And everything is done here in the US. Usually it takes about a year to a year and a half to get your green card. Okay, so that's one kind of type of way to adjust your status here in the US if you came in with a visa. Other ways to adjust status here in the US if you did not come in with a visa. So if you did not come in with a visa, there's specific ways that you can do it. It's not the rule. Those are exceptions to the rule. For example, if you have an old petition, so someone applied for you or for your parents in the past before April 30th, 2001, you could be protected under a law that's called INA 245I. In the technical term. So there's a special protection for you, 245I protection, and you might be able to adjust your status even if you didn't come with a visa. Okay. Other protections could be humanitarian options like the U visa or the T visa. Okay, if you are eligible for those, if you've been a victim of a crime or of trafficking, then you might be eligible to do the whole process here without leaving. Okay, and another option, which I've discussed in the past, is the option of VAWA. So And I want to spend some time talking about it because I think it's really important. Not a lot of people know about this option, and not a lot of lawyers even talk to their clients or screen for this. So it's important to have this in your mind if you're in the situation. So what is VAWA? What is that option? So VAWA is a way to self-petition yourself for a green card without having a petitioner. And it allows you to adjust your status to apply for a green card in the US without leaving. So if you came in without permission, without a visa, you can still get your green card without leaving the US through VAWA, through a self-petition. Other great benefits is that you get a work permit, and you get, which is huge, Social Security number, all that. You can apply for it while your petition is pending. So how do you qualify for VAWA? You need to be either married to a U.S. citizen or green card holder, or you have been married to a U.S. citizen or green card holder in the last 2 years. So you could be divorced, but you have to have been married to a U.S. citizen, green card holder, and have lived with them and suffered in that relationship. Okay, so VAWA is based on the Violence Against Women Act, and it's based on suffering cruelty, extreme cruelty, or abuse by your spouse. So if this is relevant to you, it could be a great way for you to self-petition yourself without a petitioner and without the need to leave, even if you came in without permission, okay? Because usually if you come in without a visa, the general way is that you have to leave. So even if you get married to a U.S. citizen, if you came in without permission, you don't have those three eligibility categories that you have to apply for your green card here in the US. You don't have that legal entry. So the way you would do it is you would leave the US, right, and do the process abroad. And there's a way that you can do it. You can ask for a waiver. It's a 601 waiver, 601A, and it's a provisional waiver. So you ask for the waiver before you leave, but you still need to leave. Okay, so that's the general way. Applying for adjustment of status is a huge benefit because you do not need to leave the country. You can do everything from the convenience here in the US. There's no risk. You don't have to leave. So it's a huge benefit. And if you are interested in applying for a green card, contact us. Okay, we would love to help you and evaluate your case and see if you'd be eligible for one of the perhaps exceptions if you did not come in with a visa. So I'm just looking at the questions. Priority date for EB2 is 2015 now. Yeah, there's been movement on the October 2020 bulletin, both in the EB2 and the EB3 categories. Not sure off the top of my head if it's 2015 for EB2. If it's relevant for you, you can contact us and we can look that up for you. Okay, but definitely significant movement. EB3 is actually before EB2 right now, which is really rare because usually EB2 is a more professional category than EB3, but a lot of movement there in the visa bulletin. In terms of, there's another question that's asking about chain migration. If you want to specify what you mean by that, what your question is, I would love to help you and see if I can answer. Chain migration is when, I guess it refers to when someone is applying for a family member and then that family member petitions another family member. So it's kind of like a chain. And that's perfectly legal and the option is available. Okay. If you have any other questions, feel free to write them in the comments and I would love to answer them. Let me see right here if there's anything else going on. No, I don't see any more questions. So I just put up my information. Our firm is Brudner Law. That's our number. You can call, you can text us. You can check out our website. There's a lot of information there about adjustment of status, about applying for a green card, petitioning a family member, a lot of interesting stuff there. So that's it for today. Wish everyone a great afternoon. I'm going to be here tomorrow talking about another immigration topic. So if you have any questions, feel free to send us a message and maybe we'll answer them tomorrow or ask them live, even better. So in the meantime, everybody have a great afternoon and see you tomorrow.